Hello everyone, I'm Amir Adibi of Patentlawyer.io, and today I'm going to discuss Secure Axcess versus PNC Bank. This case was decided by the Federal Circuit on June 6, 2017. In this case, the Federal Circuit denied petitions for rehearing en banc of the Federal Circuit's original panel decision that narrowly construed the covered business method statute. In the original decision, the Federal Circuit construed the CBM review statute as requiring that the claims recite limitations directed to a financial product or service for CBM review to apply. Before we address the case, we need to first look at Section 18D1 of the America Invents Act. The America Invents Act provided for this 8-year program for reviewing the validity of CBM patents. Unlike inter-party review, the CBM review program has been small in scale. Section 18D1 states that a CBM patent is one that claims a method or corresponding apparatus for performing data processing or other operations used in the practice, administration, or management of a financial product or service. CBM review, the program, is set to expire on September 16, 2020. This case involves Claim 24 of U.S. Patent Number 7631191. The other claims of the patent were defeated in a separate IPR that was affirmed by this panel. To briefly summarize, the majority reads the CBM statute as requiring a claim to recite financial products or services, limitations for CBM review to be available. The majority construction is narrow. The majority, on the other hand, reads the CBM statute more broadly and does not require strict recital of the financial products or services limitations to be in the claims. The minority view permits CBM review where the specification describes financial-related applications of the claimed invention. I'm going to first address the majority opinion by Judge Taranto. In Judge Taranto's majority opinion, the application of the CBM statute is on what the patent claims. Under Justice Taranto's majority opinion, it is improper to look for a financial services-related application in the patent specification. The court goes into textual analysis whether the verb claims in the statute applies to both the method or corresponding apparatus language and the used in practice, administration, or management of a financial product or service language, or if it just applies to the method or corresponding apparatus language. Justice Taranto's majority opinion says that it must apply to both the method or corresponding apparatus language as well as the use in practice, administration, or management language. Any other interpretation, according to the majority, would be inconsistent with statutory interpretation and with prior precedents. Every CBM review has involved a reference to a financial element in at least one claim. Judge Taranto addresses Judge Lourie's dissent, which we haven't yet gotten to. Judge Lourie interprets the CBM statute as focusing on the specification and defendants sued under the patent. In this case, all embodiments disclosed in the patented issue involve financial applications. Also, the patent was asserted only against financial institutions. Judge Taranto responds by pointing out that the statute clearly focuses on what the patent claims. The specification, uses, or patentee's infringement complaints should not matter. Judge Taranto also responds by saying that the extent of CBM review under the dissent's view would be indeterminate. For example, what type of suits would apply, or what mention of banking or finance in the application would be required. As Judge Taranto points out, all of these problems are avoided through a strict reading of the statute. If Congress wants to broaden the scope of it, then Congress has the power to do so. Judge Taranto explains that this particular issue occurs rarely. Other remedies are available, including IPR, re-exam, and litigation. Next, I'm going to discuss Justice Lourie's dissent, where I point out the arguments that were most interesting to me. Now, Justice Lourie pointed out that CBM review was created to provide a speedy and inexpensive alternative to litigation. The majority frustrates Congress's intent. Justice Lourie pointed out that patent holders can claim around CBM review even though the claim squarely covers financial applications. Justice Lourie also explains that inter-party review and post-grant review is not sufficient. CBM review permits validity challenges to issued patents that are not available in an IPR, for example, under Section 101 or Section 112. Remember that Section 101 has been used extensively to invalidate patents directed to software-related innovations. Regarding post-grant review, or PGR, only patents having a claim with a priority date on or after March 16, 2013 are subject to PGR. Plus, the PGR petition must be filed within 9 months of the patent's grant. So PGR is not available for many of the patents that Congress expressed concern when drafting the CBM review statute. Returning to the focus on the specification and infringement suits, Judge Lourie reiterated that the patent only describes financial-related applications. Judge Lourie pointed out that only financial institutions had been sued. Judge Lourie also argued that requiring financial language to be in the claim is inconsistent with the legislative background of the statute. Citing the majority view that a patent would qualify for CBM review if it claimed any operations that happened to be used in the financial industry, Judge Lourie responded by saying that common sense would prevent this from happening. Judge Lourie concludes by stating that the 191 patent is a CBM patent because the specification describes financial-related embodiments of the claimed invention. To the minority, the CBM statute is construed so as not to require explicit financial-related limitations in the claims. To summarize, the majority reads the CBM statute as requiring a claim that specifically recites limitations directed to financial products or services. For the majority view, it is improper to look at anything else but the claim when determining whether CBM review is available. The minority, on the other hand, reads the CBM statute as not requiring strict recital of the financial products or services in the claims, so long as the specification describes financial-related applications of the claimed invention. If you wish, please argue the merits of the case in the comments section below. Thank you for watching.